Should I place my last will and testament in my safe deposit box? I would tell you not to do that, not to do it. Take your last will and testament and place it into a safe location, an actual safe inside of your home, or a fireproof lockbox, or at the very least, in a cabinet in your house. This way, it achieves a couple of things. You know where it is, any of those three methods. You know where it is. It's accessible for your loved ones or executor at the time of usage, and the actual safe or a fireproof lockbox would protect you in the event of a fire, maybe a flood. If you place it into an institution, into a safe deposit box, depends on who owns it. But if you own the safe deposit box and you pass away, when your loved one, executor, could be the same, could be different, goes to the box, the bank most probably will not give them access. Yeah, that's true. Now, even if you have a joint owner, if you share with the bank personnel, the manager, the person at the desk on the side, if you share with them that the co-owner passed away, it will also freeze the contents of the safe deposit box. So let's say it's a husband and a wife, and the surviving spouse goes. It's not an issue if all of those assets were going to go to I shouldn't have said it's not an issue. What I mean to say is, if all of the assets within the box are going to go to the surviving spouse anyway, it's not an issue of thievery or stealing the jewelry or personal heirlooms and not distributing them to other people. It's purely, survivor takes all. Still, the bank will freeze the assets. They might make you or permit you to look at them, but even then you probably need a court order to do that. So do not keep, unless that's the only place you could put it, but it's going to cause delay because there's a court process. You have to go to court to get permission to look inside the box. You go to the court with certain documents, that certified order. They'll open up the box. Now, if you have a key, they'll use your key. If you don't have a key, you have to coordinate to have the box drilled open. But even then, they will only let you look into the box. They'll take an inventory, and then you have to leave. You then have to take the inventory, the list, 1 through 6, however many items are in there, go back to the court and get the permission and authority to actually retrieve those assets. So it's a pain in the neck, cumbersome process. Don't do it. If you have a last will and testament and you want to put it in someone else's safe deposit box, like an adult child, you could consider doing that. Although, what if you want to change it? What if you want to make a new will? You want to access it. You want to rip that will up. You want to make something new. Well, you still can make a new will, but you wouldn't be able to access that will and rip it up or destroy it or put a line through it, strike it, revoke. Couldn't do it to the actual will. And then perhaps at some future point, there might be a will contest, or there could be a will contest where someone would say, hey, the only reason you did that new will is because you forgot that you had the old will, or you didn't have access to the old will, or something like that. I'm all about keeping things uncomplicated. So inside the house, fireproof box. Final answer.